innovation lightning round. And we have 4 thought-provoking, mind-bending, exciting, super awesome talks for you all. So please settle in and take your seats. And we have Owen Byrd, Chief Evangelist and General Counsel of Lex Machina, serve as the MC for this lightning round. So I will turn it over to Owen. Owen.
Thank you, Roland, and thanks everybody for sticking with us. We are going to make this slightly shorter than was planned in order to get you caught up and to give our final speaker of the day a running start at 5:30. I'm delighted to MC this lightning round on innovation. Lex Machina, as many of you know, emerged out of the Stanford legal tech ecosystem, and so we count ourselves as Codex-affiliated innovators and are delighted to support the others who are up here today. So we're going to move right to each of the lightning round presentations. We're going to start with Pablo Arredondo, who's the co-founder and chief legal research officer at Casetext. He is also a Codex fellow. He is focused on identifying and leveraging patterns in judicial opinions. And most importantly, he and I just realized that we are among the shrinking group that has been to every one of these FutureLaw conferences. So Pablo, go ahead.
Yes, indeed, and I've seen the head count grow. I've also seen the average income grow a lot faster than the head count, which I think says something about those early days of Codex. Okay, so this slide obviously needs no more explanation. No, I kid. Okay, are there any folks who play chess here? Any chess enthusiasts? All right, I'm very happy to see that, as did John McCarthy, one of the original people who worked in AI. What you're seeing here is a game between, playing black is the leading open sourced crowdsourced system called Stockfish, the result of decades of, many years of multiple people, experts putting in their, everything they've got. And playing white is a system that Google created that taught itself to play chess in 4 hours by playing itself over and over and over, right? Now, you've heard about the Go game probably a lot more. I'm a little demoralized because I thought chess was the great game until I saw that Go is much older and much more complicated. But, even without being a chess master, you might notice that it's almost like black's pieces are trying to flee the game and get out of there at the top right? So AI is doing these amazing things, these things that truly boggle our mind, right? And yet, law, really, guys? If we're really serious about law right now, if you ask somebody to summarize a case holding in their own words, it's not going to come close to, we can name, Julie, right? It might say, I can grab the sentence I think is related to the holding, right? It might do something like that, but it's not going to do anything close to what a human's going to do. So as we debate whether or not these machines are going to replace lawyers, let's also wonder, are they ever going to replace second-year law students, right, who are hungover? And it matters to be able to summarize a case concisely, right? In fact, there are, this is a dramatization of what an editor room at one of the major legal research platforms might look like, creating these very useful summaries. And here I'm going to depict them. Apologies to our guest from Lexis and our host from Lexis. Next year, it will be your screenshot. Today, I went with Westlaw's. These are quite powerful things to have, right, at the top of your case. And it would be great if you could automate it, right? And there'd be tons of money to be made. Think about the amount of money that would be made from a company that had an AI that had some semblance of real language, right? Go have a discussion with Alexa about a legal concept, right? I think, and I've seen this before, I used to work in bioethics back when I was 19. And there was this talk, everything was going to change immediately, everything, it was all impending, and it remained like that for decades and decades, right? And of course, a lot of these conversations, if you go to the 1970 Stanford Law Review, you're going to find a great article about artificial intelligence and legal researching, right? So we're 50 years into the bleeding edge of all of this, right? Okay, So what I'm going to talk about is unnatural language processing. So I made my title the fourth slide. It's very avant-garde of me, right? You kind of fade into it. Okay. And all I mean by that is that there are, in a world where the AI cannot do these basic things, right? It doesn't mean we give up, I think. I think we need to think about, are there idiosyncrasies to judicial opinions that we might exploit? And this has been, those of you who know me really well have definitely heard me talk about this, so apologies to you guys. This is direct from case law, right? Judges, unlike most people, summarize cases in a very explicit format. They do it in these explanatory parentheticals. And in fact, there's something called the Blue Book, which I hated when I was in law school. I hated when I was practicing, but I love now that I do legal informatics. Because what the Blue Book is basically should be called is, you can regex this now, right? If you write something very simple, and so all of the parentheticals start with present participles, right? John B. Doe holding that, right? Jane B. Smith finding that. And so this is a word cloud of all the ones I pulled out. You can see all the things that courts do to things, right? They hold, they recognize, they apply, right? So a very simple pattern like this created 2.4 million concise case summaries in a database, right? That's a lot of summaries. And they're written by judges, right? That's like a century of judge work, right? That was created by the simplest of patterns. And you know it's really easy because I was able to do it. That's the acid test, actually. And so we've created a database where you can search all of these, right? This sort of celestial treatise footnote, right? Of millions and millions of these case summaries, right? All right, go back to our student. Let's say we said, here's a case. I want you to find cases that have the same holding. Again, AI, please. Oh, I can find paragraphs where the vector, the cosine similarity is pretty good. No, come on. It can't do it. I haven't even exploited. I want to harvest the one I haven't even yet. Judges hundreds of thousands of times will just put same right next to it to say this is a case with the same holding, right? You could instantly create the ability to say, would you like to see cases that have the same holding? Just by explaining that. All right, show me how this case has been treated, right? I want to know how these cases have been treated. And this Ashkan, is Ashkan still with us? You heard earlier about the attempt to develop a citator through machine learning by using some of these abilities to take what Fastcase did with their bad law bot, make that a training set. And we played with this too. And don't get me wrong, it's kind of cool sometimes to see that the word today is highly correlated with a case being overturned. Because when the Supreme Court reverses itself, it likes to do the fanfare and it'll say, we today overrule this, right? Okay, that comes out, that helps you a little bit. But it's very limited. Consider then these parentheticals. Now imagine if you were considering the case Terry and you wanted to see how subsequent cases have treated it. These concise descriptions, again written by judges, they don't just apply to bad law, right? You could call this good law bot. You could call this extending the holding bot, right? And they actually get into the fact patterns, right? So again, AI, I think, is in some ways profoundly limited when it comes to language. And I'd love to be wrong. And I'm told that we're just about to hit that exponential point, right? Everything's going to change because we're on this exponential curve. I'm profoundly curious to know if that's going to happen or not. But where we are before that right now, again, go ask Alexa about a legal concept and ask yourself, are really lawyers in jeopardy in the short term right now? All right. There's even simpler patterns like but see that they use, but we'll skip that. Okay. So finally, and this is the one I think is sort of in some ways the richest pattern that I've been able to exploit. If we asked Julie to say, go find me the most fundamental legal principles in an area of law. Go find me the sort of scaffolding, those key principles that then make up the rest. Everything else is sort of fleshing it out. And if you asked a machine to do this, and I think our friends from Lexis have known that if you can look for like repeat patterns, right? If something gets quoted a lot, chances are it's legally active, and that's powerful. You can pull things out. But distinguishing that from sort of the fundamental ones is harder. And it turns out that there's a pattern that is very short, that's not dictated by the Blue Book. It's not something that they have to use. They just did. And they did it hundreds of thousands of times, and it turns out, and this is a map of the heyday of the British Empire, everywhere that army marched bringing its common law, this phrase came along with it, right? So you're going to find this phrase in Canada. You saw this phrase in Australia. It's done just amazingly well for itself. And that phrase is, it is well settled. And 3 of these words would be stop words to a data scientist, right? These are little stop words that could, That phrase is invariably followed by a concise articulation of a legal principle. And it's got a cousin, it is well established. There's hundreds of thousands of those. There's one more I found, it is axiomatic. There's only about 50,000 of those. And that is the most misused phrase, I think, in the entire history of law, right? They say things like, it is axiomatic that grandkids love their grandparents. It might be true that they do, but is Western jurisprudence going to fall to pieces, right, if you were to remove that? Anyway, so what I hope to instill in you guys, and some of you are working in judicial opinions, others of you are going to be working in other corpuses of documents, right? I highly suggest you not necessarily wait for the machines to learn how to speak and read English, right? If that happens, great. In the interim, ask yourselves, are there specific nuances to this language, to these documents, which I can quickly exploit to create immense value, immense organization? And I think you should do that, because I think that sometimes we're so into the heaviest stuff that we might lose track of some of the easier things that we can do. Lastly on this, I showed this little database to my con law professor, Larry Lessig, the great Larry Lessig, and he wrote back, this is kind of cool, but Pablo, I want to know, how do principles become well settled, actually, right? Now, that's not a regex, but of course, it's Larry Lessig. I said, of course, Professor Lessig, I'll go get that right away, right? Well, okay. So did some preliminary work with Dan Katz and Michael Irina. We've actually pulled out all these well-settled sentences, removed their little prefaces, and if anyone would like to actually answer Professor Lessig's question, I welcome them to partake in that data. It's on a GitHub repository, and this has just been a few examples of what you can do when you process the very unnatural language of judicial opinions. Thank you guys so much.
Pablo, thank you. Our next presenter, Carlos Gamez, is the Senior Director of Innovation for Thomson Reuters Legal Business, where he defines innovation strategy and then executes on innovation priorities. And he and I are very proud that since Lex Machina is part of the Lexis family and he's with TR, this is proof positive that at least at the level of thought leadership in the legal tech community, people can collaborate on a panel and beyond in order to sort of move best practices and innovation forward.
Thanks so much, Owen, and thank you, everyone. So I'm going to rush through this, hopefully get some time for questions and answers and for the next speaker. But what I'm going to try to do is to consolidate or contextualize a lot of what has been said today, right? So I'm here to argue in defense of the lawyer's value proposition in a way, right? So we look at, let me see if this works. All right, so a lot has been said about whether lawyers are going to go away, their task disintermediation, and some of the tasks that lawyers perform today are no longer going to be performed by lawyers in the future, right? You know, that has been said. A lot has been said as well about the legal skills or the skills that lawyers will need to develop in order to perform legal services. And I guess it's going to be a combination of that, right? But what we should not lose sight of is why lawyers are hired by their clients. You know, what's the job that clients hire lawyers to do? Essentially, you can say that they hire them to provide contextual advice. They hire them to manage risk, and they hire them to help navigate complicated regulated processes. Now, at the core of this, and as someone mentioned before, where does the buck stop? And it's about legal defensibility and compliance. Advice needs to be legally defensible, hold up in court, and strategies need to be legally defensible and compliant. And it's not the fact that a lawyer can have insurance malpractice that is going to be the stop. It's the fact that the lawyer needs to stand behind its work or his or her work. Now, we think that lawyers will need to specialize to deliver this value proposition, but it's going to be a very different type of specialization, very different from what we see today, right? We think that the trends are driving towards specialization by why legal services and by how legal services. And what I mean by this is you're going to start seeing more lawyers specialize on being better advisors, being masters of context, and being industry experts, right? In order to provide that strategic contextual advice. And you're going to see lawyers specializing more and more on how legal services are delivered. Now, these are things that are already happening today, but we should be seeing that happening more specifically in the future. And you know, you could argue that a lot of professionals will be able to provide the services that lawyers provide today, right? You know, there are financial advisors that can provide contextualized expertise. There are legal operations or operations people that are non-lawyers that can be very good at managing legal operations. But at the end of the day, what is going to drive the value proposition, what will generate this competitive advantage for lawyers is, again, the legal defensibility of the legal advice or the legal process as it's being designed, because laws change and context changes, and lawyers need to be involved in the design of these the delivery of these legal services. This is the competitive advantage. This is what makes the value proposition unique. And I don't know how many people recognize this person here. Show of hands. All right, well, it's a good movie. Check out The Godfather. This is Tom Hagen, the consigliere, right? This is your prototypical why lawyer, right? Client-centric. He understands the business. He serves one client. He has a special practice even though no one knows what firm he works at because he is part of the Godfather's industry. He is still a lawyer. He provides legal advice. He does not get mixed up in non-legal activities, but he is an industry expert, right? Now, kind of, right? But the idea here is that, you know, these trusted advisors are going to be enhanced by innovations that are affecting the legal industry, right? And by innovation, I don't just mean technologies. They will be enhanced by methodologies like the ones you've heard Margaret Hagen speak here earlier, like client centricity and empathy and legal design and understanding and human-centered design. So these why lawyers will need to master the understanding of their clients using these methodologies. These why lawyers will also be experts in business practices, traditional old school business practices like account management and sales. They need to understand, they will be more client-centric and understand where their clients operate. Now, they will also be immersed in the operating environment of their clients, right? We are starting to see this today. 27% of firms, large law firms, are now organized or have some sort of grouping categories by industry. Whereas when I used to practice law over 10 years ago, it used to be primarily practice areas, right? This is going to go away. And lawyers, these why lawyers, these trusted advisor type lawyers are now part of multidisciplinary teams, and this will be increasingly so. They will be found not in law firms, not in corporations. They will be part of industry groups within heavily regulated corporations like healthcare companies. They will be part of data analytics and fraud prevention companies like in Palantir. They will be part of the delivery teams of audit and accounting services, and they will be part of research teams, right? These are experts that are legal experts, again. They're not providing non-legal services, but they are part of teams that are contextualized in a very different way as from what we see today. Now, these legal experts are also going to benefit from artificial intelligence, machine power tools, and tools that exist in the market today. They need to know how to use these tools and aggregate services that benefit from the usage of these tools in order to become more data-driven, right? The analysis that their clients will require from them, just as they would any other advisor, needs to be substantiated by data. Now, the other type of lawyer, right, the mainly how lawyer, and some people will argue, well, this isn't legal practice and they're not going to be generating a lot of value for their clients if they're dedicated to these types of activities. I would argue that a lot of the advisors in, for example, Big Four accounting firms are actually making a lot of money focusing on making processes more efficient and delivering quality services even in high volume tests. I used to be an IP lawyer, and I can tell you that most of the money from IP, the IP practice actually came from the agency side of things and managing that process versus the litigation side of things. So these mainly how lawyers are going to be, and some people like Lucy Bastley here will call them unicorn lawyers, legal operations experts, legal practice management experts. They need to be well-versed in technology. They need to be well-versed in business strategy and processes, understand data, understand project management and program management. But you know, the reality is that these lawyers are already active, and they are active in many different ways, in many different environments. You can start seeing them, since 8 years ago, with nearshoring, offshoring, lawyers need to be participating in the design of the delivery of legal services. So even though the term is offshoring, the people designing the process that it's being offshored, the designers of that process are lawyers, are licensed lawyers who need to be held accountable for the end product of the work. right? And you start seeing also efforts like process mapping efforts and legal practice management efforts within law firms, within corporations. And it's also lawyers who understand that the law will change, that they need to be actively involved in the design and the delivery of those services, even if they are relying on third-party professionals in providing those services. Same thing with analytics, and same thing with AI and cognitive computing. A lot of the people designing these tools at my company, at Owen's companies, and other places are actually lawyers, and they need to be lawyers because they need to understand the workflow and the possibilities of changing those workflows. A lot of the legal innovations actually that have had the greatest impact, for example, e-discovery and predictive coding, require an understanding of what would be admissible at what time in court, or how far you can stretch the law in order to apply legal innovation. So this brings us back to the future. When Roland said, can we talk about the future skills of lawyers? I don't think lawyers will need to develop that many a lot of different skills from what they are being taught today, but they do need to develop more practical skills that, the way I would summarize this is, regardless of where they sit, regardless of if they're in a large corporate environment, if they're providing access to justice or services to low-income clients, they need to be expert buyers and aggregators of services, not just service providers, right? A lawyer in a corporation, a corporate legal department lawyer, will be both a buyer and a service provider at any point in their careers, right? Lawyers will also need to understand that technology will bring efficiency, but they need to understand the context in order to apply the right tool for the right problem, for the right legal issue. And I think that, again, not to beat on their horse here, but I don't think lawyers will go away. I think lawyers need to be involved in the design and the delivery of legal services, because at the end of the day, the buck stops with them as the legal advisors and the people that are experts in managing legal risk, because they are able to stand by their advice or their legal service. And in the event that they need to modify that, they are the ones that will be able to do that. They need to be able to ensure legal defensibility of the service. So that's all I have. Yeah.
Okay. Thank you. Perfect. Thank you, Carlos. The next legal innovation we're going to hear about is the Stanford NPE, or non-practicing entity, litigation database, and we will hear from John Polansky, who is a student here at Stanford Law School and the co-author of the project's report, as well as Irina Zaks, who is the former web developer here for SLS and now founder of Fibonacci Web Studio, which develops advanced web solutions for researchers and academics. And here goes your 8 minutes.
Thank you, Owen. As Owen mentioned, my name is John Polansky. I'm a third-year law student here at Stanford, and for the last 2 years, I've been a research assistant on this project, supporting Sean Miller and Mark Lemley and Stanford generally in building the largest publicly available comprehensive data set on patent litigation in the United States. And this is in light of the problem, or at least the perceived problem, that patent trolls, otherwise known as a patent assertion entity, have been having on litigation in the US. So what we're doing here, and I only have a minute or two, and then I'm going to turn it over to Irina, because the main point of today's talk is how her work and her tools are helping us create this database. But what we're doing is analyzing every single patent litigation starting from the year 2000 to present and moving forward. And we're taking each entity involved that asserts a patent, and we're categorizing that entity as one of 12 different types. Of those 12 types, we have one type for product companies, a company that offers a product or sells a service other than licensing patents. All other 11 types are non-practicing entities. We also have an undetermined category, but we're looking at 12 types. So one type for product companies, and the other 11 types are some form of MPE. And in terms of the sheer volume of cases, from the year 2000 to 2015, there were about 54,000 distinct patent litigations filed, we've already processed about 80% of those cases. So we have comprehensive data on the entities and the type of entity involved in about 40 to 42,000 of those cases. Now, for 2016 and 2017 and moving forward, we want to make this process happen quickly and bring it to the public in an accessible way. So we've done about 15% of the 2016 and 2017 cases. And just real quick, here's a snapshot of some of the data that we can see with our data. This is very preliminary. There's so much that can be done. We can look at the types of entities, the timeline, the time trends. Here you see that the number of total lawsuits has spiked dramatically starting from about the year 2000. And we want to look into why that happened. And we can, instead of looking at lawsuits, consider lawsuit defendant pairs. In other words, instead of one lawsuit with 20 defendants being counted as one lawsuit, we count the number of pairs. So 20 pairs in the case of one suit being filed against 20 defendants. That lets us compare to cases that are filed against single defendants. Go ahead. So what we were doing, we were using Excel, we were using very rudimentary tools to do this classification. What Irina is helping us with is to build a system that we can use very quickly to upload publicly available data about new cases, classify the entities in those cases, and then do quality control and error checking on the system. So with that, I will let Irina discuss her system.
Hello, hi everybody. My name is Irina. I'm a Drupal developer, and here today I'm representing technology in the legal world. And we're using Drupal framework that enables rapid deployment of applications for legal research. How many of you heard word Drupal before? Okay, so I don't need to go into details on that. Great, saves me 7 minutes of the presentation. So before I go into what we're doing, or how we're doing, I want to address the question why we're doing, because that's the driving motivation for us, like why we need this or that or this tool. And we listed out four or five major things that a legal researcher wants to get out of technology. One is there's huge volume of data that is coming fresh every day, so we need to be able to quickly process it. We need to reuse previous data that's already in the system. You don't want to code Google.inc, Google, inc, Google Inc, and also Google all caps and Google without ink. When you're doing categorization, you want to be able to cross-navigate system. You want to make sure that you have very good quality control. We want to provide accurate data. That's very important. And the last piece, we want to share this research, right? Like I'm part of Open Source Lab. We're very much like promoting sharing what is important and then developing internally what what needs to work on in detail. So this is a quick summary of what Drupal does, and here's a demo of how we get from this wonderful, very beautiful CSV comprehensive thing with the titles of the columns. That's the most important piece, into this, where you can see and say, oh, let me see what was happening. I actually want to see a bigger picture. Okay, what was the total amount? Here it is, here's the click. So from that spreadsheet to this website, thanks to Drupal, it took us 4 months, which is approximately, I'd say, 80% of the standard development time. We're cutting 80%, so we spent 20% of this time that would be normally spent. So how do we do it? Let's go through the steps. First thing is we take your CSV and we create Drupal speaking content type. Content type is the major data object where we identify data structure. I can't underestimate the importance of this step because that will define how we will be able then to search, parse, and combine information and display it. After we parsed it, we map these new things into the source of CSV. So something is called civil action is mapped to civil action, but if I need to give it a slightly different claim, like this was imported plaintiff versus defendant, there's flexibility. I want to bring to your attention that it's all done in plain English. You don't really have to do left join, right join, what's the type of the data. It's all plain English, and you can read it. And by the way, Drupal is available in any, I think, almost any language. Next step is, okay, we defined what we have the data. We define how we're going to import it. Then we say, okay, this was the data for previous years, 2015. I want to bring in data. So I'm going to say add this new thing, put the name, upload file, and click Save and Import. Import takes about probably 3 to 5 minutes, which we don't have today. So we're going to go ahead and move to already imported things. And once you click Import, all the cases are coming in the very organized table. You can sort, you can filter, and let's say I want to, and you can assign cases to different arrays because you want things to be done quickly. So you can say, okay, some arrays are going to be working on cases that were filed in March, some are going to work on cases that are filed in January, right? So I say, okay, please show me cases with filing date between January 2016 and January 31st, 2016. Then I say search.
Irina, we're going to have to wrap up, unfortunately.
Okay, and then once you assign it, everything goes into my dashboard from where I can edit the case, which is very conveniently color-coded. I have ways to add information that I research on the internet. And once I categorize it, you can do it. It shows up, you mark the case as completed, and you're done. Voila. Thank you very much. If you have...
Thank you, Irina.
Very conveniently, we have Drupal camp tomorrow, so if somebody wants to hear all the details, that takes around 60 minutes, please come join us at 3 o'clock.
Thank you, and thanks to all of the panelists for putting up with this being a true lightning round. Our final presenter is Oliver Goodenough, who's the co-director of the Center for Legal Innovation and professor of law at Vermont Law School. He's also Codex-affiliated faculty and a co-founder and director of Scopus Labs, which applies machine learning text analytics to legislation and regulation. Professor.
Thank you. Thank you very much. For those of you who are involved in legal technology, there is that moment when you try and explain what you're doing to your friends and relatives. I had a couple of experiences. I was at a Seder on Friday night, and the person next to me had this conversation. I was at an Easter dinner on Sunday, and my cousin Margaret sitting next to me had this conversation. It is a recurring conversation. Part of it is you explain what you're doing, and then they say, but what happens to ambiguity or some word about that, that there's this kind of notion that the law has this wiggle room, and that's really good, and if you put it into code, we're going to lose the wiggle room, and what's going to go on? And this is my explanation. I'm sure that there are other explanations out there. I look forward to hearing them at the reception. But my explanation is really to ask the question, is ambiguity in legal specification a feature or a bug? Now, one of the nice things about this feature bug piece, and I got off the internet, fair use here, right? Anyway, it is an example that a feature is basically a bug dressed up in explanatory clothing. So it is often put forward as this notion of ambiguity is that it's put forward as a reason why an objection for automating legal processes, but is it really desirable, or is it just we've gotten used to it and we do the best we can with it as lawyers? So I asked myself, what is ambiguity in law? By the way, this is kind of a version of what I told cousin Margaret, and hopefully it satisfied her, and we'll see whether it works with you. Difficulty in reaching conclusions about facts or outcomes. There's just difficulty. Some reasons why it's just kind of difficulty. But I want to make a distinction as you think about it between rule ambiguity and event ambiguity, because I think this is a good starting point. Rule ambiguity, the pertinent facts, events may be well established, but the outcome resulting from those facts is not clearly specified. That would be a rule ambiguity. Most lawyers would not view rule ambiguity as a plus in most circumstances. If you're trying to actually write a good contract, you don't want to, is the money due or not? And the answer is, I don't know. Well, no, that's what, hey, I know all the facts. I should know whether the money's due or not. The point of the law is to project dependable order into a set of future interactions. At least that's a way of thinking about it. And so rule ambiguity is a relatively narrow piece of this. Somebody pointed out to me recently that the new tax law was full of rule ambiguity. That's not a good piece. That's a bug, not a feature, as you go forward. What is about event ambiguity? Event ambiguity is more pervasive, I think, in law. Has the trigger happened? Often we've got some kind of trigger event, some kind of trigger fact that has the trigger happen. That can be hard. If so, then the consequences will flow, but determining the events is notoriously difficult. In computing more generally, this is sometimes termed as a feature extraction problem. Can we know did something happen or not? Think about facial recognition software. Is the person viewed really Kim Kardashian, okay, or somebody else? If it's a Kardashian, we implement plan A. If it's not a Kardashian, we implement plan B. But we've got to have that conclusion be reached. The trick is in recognition, not reaction. Okay, the reaction may be pretty well specified. That's the rule. The recognition piece is not. I don't have a Kardashian illustration, but I do have the muffin or dog one. I thank Meng Wong for pointing this out one. Is it a dog or is it a muffin? If it's a dog, you do X. If it's a muffin, you do Y. And in some of them it's relatively easy. Some it's kind of hard, because we don't necessarily know. There's a whole string of muffin or dog things on the internet if you Google it. Now. By the way, this problem, is in a sense the jury problem, right? The law is actually pretty good at this. It says, is it a muffin or a dog? Ask 12 people in the box. That's the fact finder. That's the jury. We have a method for actually, even in the slow AI of traditional law, we have a method for turning that over to a human-based panel to give us a determination of which it should be. So, ambiguity is sometimes, I think, therefore, really used to refer to specifying events that require human judgment to resolve. And that can be a fair use of it, I think, in this kind of context, i.e. something like reasonable efforts or timely delivery. We could specify delivery by 12 p.m. on the following date. Or we could say timely. And when we're saying timely, it's not that we're trying to be acute, although sometimes lawyers are. What we're really trying to do is to say that we haven't really done the work. It's a shorthand that avoids breaking the criteria down into more granular elements of measurement, and instead substituting human judgment as the decider. So it's not so much uncertainty in this case as I think it's subjectivity. It's subjectivity or something humans will do better. Again, see muffin or dog. I think that, again, going back to this, what can humans do piece that we heard earlier, I think humans may be a little better than this, although AI is getting better all the time. So, invoking a particular human black box as the event trigger, I think, is really this ask the human moment. Once the authoritative human or humans, a judge or a jury, determine that reasonable efforts were used or that it is a dog, then the application of the rule and the determined outcome becomes clear once again. So the instruction to ask a designated human is an acceptable and non-ambiguous step in a well-constructed legal logic tree. I don't think that this actually gets in the way of automation. It just says that one of the permissible steps in legal automation is ask a human for the subjective judgment on this one, because that's the widget we want to use for that purpose. That's the object for determining that, then back into the code or words. So computational law does not preclude human judgment. It just needs to be built in as a step in the process. Some events determined by automated processes, the temperature sensor in the middle of campus here can keep track of that much better than me running out with a thermometer, but others do require human judgment. So I'm saying let the machine do what machines are good at, and vice versa with humans, and just keep track of that and make that what you specify. AI judges are not a necessary component in a computationally assisted and specified legal system. So conclusions, ambiguity is mostly a bug in the legal system. except when it's a feature. And then it can often be designed into computational legal specification as easily as into natural language formulations, if a bit more blatantly. One of the problems with this is if you say, by the way, on this one, ask the human, you really expose what you're doing. And that can be a problem. Thank you very much.
We can take, Roland tells me we've got time for one or two questions. If anyone has any, please approach the mics for any of these innovators. And unless I see a bum rush to the mic, Oliver?
I'd like to make a brief point on a couple of the earlier ones here, because while I agree on some of the questions about what humans can do, obviously I think that's there. I think that there was a certain circularity to some of this, which was saying humans will be far better at reading cases and summarizing it. That presumes that the law of the future depends upon cases.
Absolutely, and that's a really important point. From my view as a litigator, we're stuck with this genome that started, it's 2 centuries ago, and that's where we have to get the fabric of our justice system. Should you remove that? Things get a lot easier.
Because again, I've argued in the past that the sort of law 3.0, that terrible cliche, is when it flips over and becomes a different system. Right. And so I think that while I agree with you in the context where we are now, right, the future of the law actually could look different in a way that we just didn't have that same kind of case system, and in which case it would be a different looking thing.
Those of us who were very early at Codex know that there was a debate about whether or not to call it the Center for Legal Informatics or the Center for Computational Law. I championed legal informatics, but perhaps one day we'll have to revisit the vote and see, where we were.
We've got one question.
Sure. So appreciate the dog and the muffin analogy, and I would like to interject one more fact point into that human intervention. It's known as the opinion committee and the issuance of opinion letters, which were required in transactions. How do you see that as a break point in logical flows of artificial intelligence and process-driven, the fact that legal opinions are required to get deals to close?
Legal opinion is to a large degree an insurance device. It is an insurance device as well as being an expert, but it's a comfort letter. It provides comfort to someone that this is likely to go forward in the way that you're talking about. I think that there are lots of pieces of the opinions that I have written in my day which were quite computational. I looked at the following 17 documents, and based on those 17 documents, it is my opinion that none of them contradicted this conclusion. And I don't think that one is fairly automatable, quite frankly. If I'm looking for a more subjective and this was done in reasonable time, then you've got to ask the human. But actually, the opinion letter, I think, is a very nice context within which you can sort out things which are fairly automatic in that sense, and those which actually might require the human. And if you begin to think about it that way, you actually clarify what you're doing. And many of my opinions had both components, and this helps you thinking about it this way may help you sort out which is which.
I'm afraid that's all the time we have, but please join me in thanking these innovators for their presentation.